So good afternoon, everyone. Conformément à l'article 108.
Pursuant to Standing Order 1082, we are continuing with our study of remediation agreements, the Shawcross Doctrine, and the discussions between the offices of the Auditor General and the government colleagues.
It's a pleasure to welcome Ms. Mary Jean Condon. Ms. Condon is the interim dean at Osgoode Hall Law School. Welcome, Ms. Condon. Can you hear me?
Yes, I can hear you very well. Thank you.
Excellent. Et nous sommes aussi rejoints.
We also have with us Maxime Saint-Hilaire, Associate Professor, Faculty of Law, Université de Sherbrooke. Are you there? I can hear you very well. Thank you. Excellent.
What I had mentioned at the previous meeting, I'm going to hold strictly to time allocations, more so than I normally do. I'd ask everyone to let witnesses to complete their answers, but witnesses also to be brief so committee members can get their questions in during their allotted time. And I appreciate you both being here. On va commencer avec Madame Condon.
We will start with Ms. Condon.
Good afternoon, committee members, and thank you for the invitation to speak to you today and for your flexibility in allowing me to appear remotely. My topic today is that of prosecutorial discretion and the Shawcross Doctrine. And I would begin by saying that I was lucky enough to study this topic with two world-renowned Canadian experts, Professor John Edwards and Professor Philip Stenning. And I will draw on their works in these remarks about the legal principles involved for about 8 to 10 minutes. Speaking as an academic, I thought it would be important to start with some first principles to put the Shawcross Doctrine into perspective. As members of the committee know, an Attorney General is required to fulfill multiple roles. He or she is required to be a legal advisor to Parliament and to the government. But he or she also exercises the prerogative power to prosecute criminal offenses. And it is this power that is the focus of attention today. It is now established by constitutional convention that the Attorney General will make an independent decision to prosecute or not to prosecute. This requires making a two-step determination about, first, the sufficiency of the evidence, and second, whether the prosecution is in the public interest. Because of the necessity to consider the public interest, commentators often say that the prosecutorial decisions made by an Attorney General are at the intersection of law and politics. And because of this intersection, many jurisdictions have appointed a Director of Public Prosecutions in order to insulate prosecutorial decision-making from the perception that political considerations are uppermost in the mind of the decision-maker. If a DPP is appointed, however, as has been the case in Canada, there are the same expectations that the DPP will exercise her or his prosecutorial power in the public interest. So how is the Attorney General or DPP supposed to discern what is in the public interest in order to exercise their discretion? As Professor Edwards argues in his book, the task of the Attorney General or DPP is a difficult exercise of weighing a number of competing considerations. And it's in this context that the Shawcross Doctrine becomes relevant. As members of the committee already know, this is a guideline that was first promulgated by Lord Shawcross, the Attorney General in the UK in the 1950s, and has since been relied upon in Canada. The doctrine says that the Attorney General must acquaint him or herself with all the relevant facts and with the considerations that affect public policy. In doing so, he or she may consult with colleagues, and in some circumstances, as Shawcross noted, he or she would be foolish not to. A good example of the need to consult in order to have a full appreciation of the issues is the well-known case in the UK from about 10 years ago, the BAE case, or British Aerospace. Here, the issue was whether considerations of national security required that the Attorney General discontinue a prosecution. It was considered not reasonable to expect that the Attorney General himself would have a full understanding of what national security would require, so he would have to seek that advice in order to inform the decision. In the case, the Attorney General consulted a wide range of informants, both inside and outside Cabinet, and the record shows that there were repeated meetings about the issue. The position taken by several of the Attorney General's parliamentary colleagues in the UK, including the Prime Minister, was that national security did require that the prosecution be discontinued. I would also note in passing here that the Canadian DPP Act explicitly says that the DPP is allowed to engage technical experts to provide advice. However, the Shawcross Doctrine is clear that the assistance and advice of colleagues is confined to informing the Attorney General of particular considerations which might affect her or his decision, and it must not consist of telling him or her what the decision ought to be. The Attorney General should not be put under pressure by colleagues, and in particular should not be put under partisan political pressure. Professor Edwards, for example, suggests in his book that the Attorney General should refuse to listen to arguments based on political expediency, but rather should apply his or her judicial mind to the circumstances at issue. This is necessary to maintain the integrity of the office and the integrity of the administration of justice. Meanwhile, Professor Stenning and others have suggested that leaving aside the problem of partisan advice, the most challenging issues arise when there are a number of competing legitimate interpretations of the public interest, so that the relative importance of each has to be assessed and balanced. Again, I would note that in the BAE case, other definitions of the public interest beyond national security were identified. Those included national commercial interests and harmonious relations between the UK and Saudi Arabia. While the Attorney General in the BAE case indicated that he had not based his decision on these factors, it remains the case that where several legitimate public interest considerations are available, ultimate responsibility is placed on the Attorney General to interpret the advice given by parliamentary colleagues or others, and to make an independent decision about how to assess them. As I've said, in this process, considerations of the integrity of the administration of justice and the rule of law are repeatedly. No specific remedy is laid out in Shawcross's original account of his doctrine as to the consequences if principles he enumerated are breached. Here, a key distinction should be made between parliamentary and legal accountability. With respect to parliamentary accountability, having made an independent decision, the Attorney General can be rendered accountable to Parliament after a matter has been concluded by being asked to account for actions taken or not taken. And parliamentary accountability may also require that an Attorney General resign if he or she no longer has the confidence of Cabinet. Meanwhile, with respect to legal accountability for a prosecutorial decision, if the prosecution is proceeded with, there will ultimately be a judicial determination as to the appropriateness of the Attorney General's decision to prosecute, in terms of whether the charges result in acquittal or conviction. On the other hand, where a prosecution is discontinued, as it was in the BAE case, for example, that decision was the subject of judicial review, with the House of Lords ultimately concluding that the rationale of national security was an appropriate one for the Attorney General to use to guide his decision. And another avenue of legal accountability that is available is the abuse of process doctrine. Let me turn for my remaining couple of minutes to deferred prosecution agreements specifically. Since the possibility of the DPP entering into one of these agreements was enacted into the Criminal Code in September of 2018. It's important to recognize that the provisions dealing with DPAs identify a long list of factors that the prosecutor is required to consider in order to determine if it's in the public interest to enter into a DPA, in addition to other conditions that must be met. There is also a list of factors identified that the prosecutor may not consider if the offense is alleged to have been committed under the Corruption of Foreign Public Officials Act. These factors are the national economic interest, the potential effect on relations with a state other than Canada, or the identity of the organization or individual involved. It appears that these factors were drawn from the OECD's Anti-Bribery Convention, which was also at issue in the BAE decision in the UK that I referred to earlier. So to conclude then, the fact that the Criminal Code amendments about DPAs identify so many appropriate and inappropriate components of the public interest could make it more feasible for the DPP or Attorney General to ascertain what the public interest is in this context, although the ranking among the various considerations is still something that will need to be addressed on a case-by-case, fact-specific basis. Thank you for your attention. I'm happy to answer any questions.
Thank you very much, Ms. Condon. Much appreciated. Et on va passer maintenant à
We will now go to Professor Saint-Hilaire. You have the floor now. Thank you. I will try to be brief. Today, I want to limit my remarks. I published an article with my colleague Martine Valois from the University of Montreal and in the Rule of Law.ca blog. The Shawcross Doctrine and the Constitutional Convention applicable can be placed in a little bit larger context, and I also want to analyze it in terms of the best practices globally. So the independence of the public prosecutor. So to go right to my main point, and then I'll make my arguments afterward. The current issue is an opportunity to examine the quality of how this is applied in Canadian law, and I think there is room for improvement. The source of my remarks on best practices around the world is the Venice Commission's report, its second report on prosecutorial independence, especially for public prosecutions. So I want to say 2 or 3 things about the Venice Commission. It is made up of independent experts in constitutional law. It is a body that was created by the Council of Europe, but now comes under a broader agreement. The Venice Commission is made up of members that are delegated from the 47 Council of Europe countries and 14 other countries, including the United States. Canada is an observer and has been for a long time. The world standards under the Venice Commission are not embodied in international law, but they are standards, best practices that should be applied. The Commission looked into this issue specifically of public prosecution independence. This institution of public prosecutors is something that is not in common law, but really came out of the European continent, where directors of public prosecutions have been created. There are other ways of working up to the level of the international standards. For example, in some countries, public prosecutors are no longer part of cabinet. The Attorney General can be excluded from Parliament. So what are the best world standards? The Commission recognizes that the executive should be able to have influence on criminal prosecutions and have some influence on prosecutors. However, the world standards recognize that the executive must not be able to give instructions on specific cases or to substitute for the public prosecutor on whether or not to prosecute a given case. At the federal level in Canada, 2006 was when the Director of Public Prosecutions was created. Under the DPP Act, sections 10 and 15 enable the DPP to give, or rather the Attorney General to give instructions or to substitute for the DPP, but this has to be published in the Gazette. The Attorney General, though, is still a member of cabinet, and that is the problem. In my opinion, the current legislation does not meet the international best standards. In the UK, the Attorney General does not sit in cabinet, and if that was done, then in Canada, then we would be closer to global standards. But to do that, we'd have to repeal sections 10 and 15 of the DPP Act. The Shawcross Doctrine was established in 1951, I believe. My colleague has just talked about this, but that constitutional convention does not change anything with respect to the role of the DPP. The problem is that the Auditor General sits in cabinet and can directly intervene in the public prosecutor's work. I also want to indicate that though my colleague talked about legal principles, in fact, as she spoke, it is clear that the Shawcross Doctrine is, in fact, a constitutional convention, and it is not a legal principle. So despite her explanation, the Shawcross Doctrine is not entirely effective because it is quite difficult to know whether in a specific case how much influence was exercised because, of course, we have the solicitor-client privilege, we have cabinet solidarity within our system. So this theory, it has limited effectiveness, but in the United Kingdom, the system is somewhat different, and we have room for improvement in Canada in this regard. We might do better by excluding the Attorney General from the cabinet and separating the two roles of legal advisor and public prosecutor. So I think that generally speaking, Canada should not be more conservative than the British are themselves. The British have actually adopted the European approach, and I think two things could be done. First, the Attorney General should no longer be part of the executive, and the role should be separated from that of the Minister of Justice, or the sections 10.1 and 15 should be repealed from the Director of Public Prosecutions Act. Thank you very much for that testimony. We will go to our first round of questions.
How much time we have for a second round and then how to allocate it. So the first round will be 6 minutes to the Conservatives, 6 to the Liberals, 6 to the NDP, 6 to the Liberals. And we're going to start with Mr. Cooper.
Great. Thank you, Mr. Chair, and thank you, Professors Condon and St. Hilaire. I will direct my question to whichever of you wishes to reply. I'm looking at Justice Rosenberg's summarization of the Shawcross Doctrine, wherein he states, second, the Attorney General is not obliged to consult with Cabinet colleagues, but is entitled to do so. So that's pretty clear. The Attorney General can consult with Cabinet colleagues. But what about the other way around? What if Cabinet colleagues approach the Attorney General? Is that appropriate?
Well, I can start providing my response to that. As I mentioned in my remarks, I think one distinction that we need to make is between partisan considerations and nonpartisan considerations that might influence a discourse between Cabinet colleagues and the Attorney General. As I mentioned, I think the better view is that the Attorney General should not pay attention or be influenced by considerations that are expressed with respect to the interests of a particular political party and so on. On the other hand, if a member of Cabinet has something to say to the Attorney General by way of advice about the definition of the public interest, I think it's for the Attorney General to make his or her own decision as to whether to listen and entertain that advice. With respect to definitions of the public interest or aspects of the public interest that the Attorney General does not have personal knowledge of, it could be helpful to hear, but the key point is that it's for the Attorney General to make up her or his own mind about any unsolicited advice that is received.
Professor St. Hilaire, do you wish to add anything?
I would just repeat what I said. That is that the Constitutional Convention and the Shawcross Doctrine are not adequate, because we can see that it is very Byzantine as a standard. It becomes very difficult institutionally to know what actually is done and what happens. So it is important for the Attorney General, who can intervene directly in prosecution cases. The Shawcross Doctrine is not enough to ensure that prosecutions are independent. So there need to be changes made, and we can't just use the Shawcross Doctrine to defend this.
And I take your position on that, but perhaps if you could respond to the question specifically. And I understand your view that the Shawcross Doctrine is insufficient, that there could be a more rigorous standard. But for example, Andrew Roman lawyer from Toronto states, quote, if the Attorney General asks for advice, a Prime Minister can respond, but offering unsolicited advice in secret about a particular ongoing case is an intrusion. Would you agree with that?
The Shawcross Doctrine is not a rule of law. It was expressed in parliamentary debate in 1951. We don't have any case law or interpretation on that. The main point in the doctrine is that the decision really is up to the Attorney General. So any information, discussion, any instructions, pressure, interference is a problem in the decision. The advice can be solicited, generally speaking, but I don't think that anyone can say that the theory really excludes providing information or advice that is not solicited. My colleague from the University of Ottawa gave a point of view, but I think there is a lot of speculation on this convention that came out of parliamentary debate. People talk about this doctrine, but I think that it is not necessarily effective, and the main thing is to not prevent the Attorney General from making the decision, and the Attorney General has a responsibility to not allow himself or herself to be influenced.
Oui, merci, Monsieur le Président. Merci à vous deux.
Thank you, and thank you to both the witnesses.
Of the Privy Council. All three said that discussions between the Prime Minister, the PMO, the Attorney General and Office are appropriate when discussing a matter like remediation agreements, and particularly as it relates to the issue of SNC-Lavalin. The Attorney General said, and I quote, "The Attorney General is not an island. These are not easy decisions that face any Attorney General, and his or her ability to get the answer right on behalf of all Canadians is only improved through discussion and debate with the rest of Cabinet." The Clerk of the Privy Council, who has served as a non-partisan public servant in Canada for decades, said, and I quote, "I can tell you with complete assurance that my view of those conversations is that they were within the boundaries of what's lawful and appropriate," close quote. The Deputy Attorney General, Madame Drouin, who is also a non-partisan public servant, gave an example from the UK, Professor Condon, that you alluded to, the BAE case. And Madame Drouin said, and I quote, "The Prime Minister saying that if the, in referring to that UK case, the Prime Minister saying that if the Attorney General continues the investigation and the prosecution, blood can be on the street. And finally, the Director decided to stop the investigation and then not to lay charges. The case was subject of judicial review, and the House of Lords did say that this very difficult and hard conversation didn't break the rule of law. So that, I think, really illustrates how serious the conversation can be," close quote from Madame Drouin, alluding to the public safety considerations. So my question for both of you is that, do you share the assessment that it is appropriate for these kinds of difficult discussions between the Attorney General, the Prime Minister, and offices about the potential use of, in this case, remediation agreement are appropriate?
I would be happy to start off with my reaction, which is really to go back to the sense that I expressed in my remarks, which is that if the responsibility on the Attorney General is to exercise this really very significant power in the public interest, there needs to be some ability to determine what the content of that public interest is. I think it would be too much to expect an individual, even very experienced lawyer in the position of an Attorney General or a DPP to always know the right answer with respect to the public interest by him or herself. And so, to me, It is important that there be sources of information and advice. As I say, they can come from inside cabinet or outside cabinet if it is needed to obtain specialized advice. But I think that in order to make the best decision possible in a world in which it is very hard to immediately know the right answer with respect to competing interpretations, it's necessary for inputs to be provided in some way to the Attorney General or DPP to help make that decision.
Okay. I'd like to perhaps hear Professor Saint-Hilaire, if you'd like to expand on the appropriateness of those discussions.
Dans la même ligne,
Well, similar to what I was saying earlier, my perspective is that there should not be any discussions within the executive on specific cases. That should not happen. Now, if you're asking me to apply the Shawcross Doctrine, I would let my colleague do it. She can do it much better than I can. My perspective is that we should not be applying that theory, and that discussions within the executive with a member of the executive on a specific case, on whether prosecution should or should not be initiated, that should not be allowed in Canada, and we can either change the act or change the structure of cabinet. I would also like to point out, as my colleague did earlier, that the measures that were introduced to the criminal code to allow for this type of agreement considerably reduce the room to maneuver. And there are factors that can be taken into account, and of course there are some that cannot be, like national economic interest in the OECD treaty.
I could go back to you for a moment. When the Director of Public Prosecutions proceeds with a matter before the courts and a prosecution, does it mean that any discussions with the Attorney General by cabinet colleagues and others, are they still appropriate after that point in time if there's still considerations to be made by the Attorney General?
It's hard to answer that question definitively, I think, but I guess my best answer would be that in general terms, once a decision has been made to lay charges, that all the rules of criminal procedure then come into play in terms of the requirement to disclose relevant evidence to the other side and so on and so forth. To me, the literature has all focused on that initial decision to prosecute or not to prosecute, or now since 2018 to enter into a remediation agreement. I think that once that decision's been made, then the normal processes of criminal procedure need to take effect.
Mr. Rankin.
Thank you. I'd like to thank both of our professors for being here. I appreciate it very much. For you, Professor Condon, you talked about how there were no specific remedies for principles being breached, but then you, I think, helpfully said that there's accountability to Parliament, for the Attorney General can talk about the decision that he or she made, and there's legal accountability mechanisms, and you referred to the abuse of process doctrine, among other things. But there's an additional remedy that I'd like to ask you to comment on, which was described by criminal defense lawyer Joseph Neuberger, who said that if there was a genuine attempt by anyone in the Prime Minister's office to speak with the Attorney General about ending an investigation or criminal prosecution of any type, that could amount to obstruction of justice and or interference with a public official. Do you accept that that could be the consequence for inappropriate interference with the exercise of independent prosecutorial discretion?
think that's a very interesting question, but I also think it's a novel question. Certainly, with respect to the offense of obstruction of justice in the criminal code, my understanding is that it is a little bit more restricted than the ability to apply it generally to discussions about starting or stopping a prosecution. And again, I would defer to my colleague or to others better versed in the detail of other criminal code provisions. But my understanding is that typically those kinds of charges are brought in relation to tampering with evidence or tampering with juror independence and so on. So
that is the most common way in which they arise. Let me ask you a question. We've had a lot of testimony, one by the Deputy Attorney General. There were questions about the nature of the Shawcross principle. Is it subjective? Is it objective? And let's assume that the facts are that the former Attorney General felt subjectively pressured. And let's look at objective criteria. I'd like to ask you to consider if a decision was made by the Director of Public Prosecutions of a final nature, we are not going to proceed after September 4th with a remediation agreement, final decision. And then there were subsequent meetings on September 17 with the Prime Minister, December 5 with the former Attorney General and his Chief of Staff, December 18th, 2 staffers in the Prime Minister's office with the former Attorney General's Chief of Staff, and then on the 19th, the Clerk of the Privy Council called to discuss this as well. What criteria can we look at in applying the Shawcross principles? For example, would you agree that in addition to the subjective approach, like the feeling of pressure that, let's assume, occurred on the part of the former Attorney General, would these factors matter to you in determining whether the Shawcross line had been crossed? Who initiated the conversation? Did they raise it repeatedly? Was there a threat, direct or veiled? And did the former Attorney General ever indicate that her decision was final? If we're trying to find principles here to know whether the line was crossed, we have the subjective as I've described, and these are the kind of criteria that I'm asking you, do you think would indicate, if they were made out on the facts, to have crossed that line?
Well, again, there does need to be a process of fact-finding in order to determine all of the aspects of what occurred. I go back to the British Aerospace case where in the context of the judicial review of the discontinuance of the prosecution, the witness statement that was provided by the Attorney General in that instance showed repeated meetings with the British ambassador to Saudi Arabia, various cabinet colleagues, the Home Secretary, and so on. And yet, in light of that information, it was still available to the House of Lords to determine that the appropriate principles had been followed with respect to the decision to discontinue the prosecution. So
obviously, very fact dependent. Very fact dependent. Yeah. So Professor John White, of the former dean of Osgoode of Queen's University, the former dean of University of Saskatchewan, one of our most eminent constitutional theorists, has said that some conversations with the Attorney General in the Canadian system are, of course, legitimate. But he says this: the legitimacy of the conversation pretty much stops when you get past "explain it to me," or "I'm going to tell you what I think, but I'm not telling you what to do." It's tricky, right? Because people try to stay on the right side of their bosses. Would you agree with that formulation?
I do agree with the formulation. I think it's very consistent with Edwards' formulation of this in his book on the Attorney General, Politics and the Public Interest. Advice is one thing, pressure is something else, and and I think he is clear that the responsibilities of the Attorney General are so important to the rule of law that pressure is inappropriate in that context.
Mr. Fraser?
Thanks. Thank you, Mr. Chair. I just want to go through some other comments that have come up in relation to this case and get your reaction to them. I note that each case obviously has to be taken on its own merits, and these things are decided on a case-by-case basis with general principles. But former BC Attorney General Brian Smith, who now works at Gowlings, when asked about this matter, said, "I would say it's quite," and I quote, "I would say it's quite legitimate for the Prime Minister to have a discussion with her about using that section, and quite legitimate for that to be a discussion in Cabinet. And that's something that she would take into account when she decided to use her discretion or not to ask or direct that remediation be offered." And the interesting thing about that quote is Mr. Smith resigned as the British Columbia Attorney General in 1988 because he felt he was improperly pressured from the Premier's office about legal matters, and he resigned his position due to what he deemed to be undue pressure. Law professor Andrew Flavel Martin of the University of British Columbia was published as saying, and I quote, "It would be appropriate for the Attorney General to consult with the PMO on remediation. For example, for the PMO to say, we're very concerned about the economic impact and the lost jobs that could occur. We think you should do this. That would be fine. To direct her to do something or to pressure her to do something, for example, to say, do it or you're fired, that would be inappropriate and very, very serious." Finally, Mark Freeman of Toronto, a former Deputy Attorney General of Ontario and ex-Chief Counsel to the Air India inquiry, told the Lawyers Daily, and I quote, that the Attorney General is obliged to consider the public interest in deciding whether to go to trial or offer remediation, and in assessing the public interest, it is necessary and proper for her to consult and receive input, including from the government. So again, these individuals, all with legal expertise, publicly stating that it is appropriate for there to be these types of discussions, all of course on a case-by-case basis, and the appropriateness will depend on each circumstance. Do you agree with the formulation of those individuals as they've arrived at their conclusions?
I think that to the extent that many of those formulations distinguish between the provision of advice and information and considerations of the public interest on the one hand, and a sense of pressure on the other, I agree with them. The thing that I think, and the reason why I mentioned the deferred prosecution agreement factors at the end of my remarks, that the thing that is interesting, and my colleague from the University of Sherbrooke made the same point, that the way that the provisions with respect to DPAs are worded creates a list of factors that are not appropriate to be considered with respect to offenses under the Corruption of Foreign Officials, Foreign Public Officials Act. So in a sense, there is a bit more direction provided in those provisions of the criminal code with respect to what the DPP can take into account and what she or he can take into account than in a traditional decision to prosecute or not to prosecute.
And just on remediation agreements, items in this case dealing with SNC-Lavalin, things short of national economic interest that may also impact on some of the reasons that a deferred prosecution agreement may be desirable in order to not impact on local economies or jobs or those sorts of things. I mean, don't you think it would be important for the Attorney General to have the full context and information surrounding those sort of issues in making any determination on the prosecution?
Sorry, my colleague wants to jump in.
No, please go ahead. I'll go after.
I think that that certainly, again, it is appropriate for individuals who are in a position to know what considerations or what the effect of various prosecutorial actions might be, to bring those to the attention of the DPP. All I'm saying is that there is now a different framework in which those considerations need to be assessed, and it's a framework that is set out in some detail in the DPA provisions in the code.
Okay, thank you, Professor Saint-Hilaire. You wanted to jump in?
Ouais, ben, je voulais juste insister.
I just wanted to emphasize that here it is very clear in the legislation that the national economic interest is not supposed to be taken into account in the decision in this case. It's in black and white in the Act that the national economic interest is excluded from consideration. And this is application of an international convention. I also want to come back to a question that came up earlier, and that is the subjective, objective distinction. I'm not sure if that's of interest to you particularly, but the Shawcross Doctrine touches on two aspects. There's the obligation of members of parliament to not influence the Attorney General, but also the obligation on the part of the Attorney General to not let herself or himself to be influenced. So it's difficult to draw a firm line between subjective and objective factors, really. The main thing is whether the Attorney General took an independent decision. There may have been information provided, unsolicited information. It's hard to see whether it's really objective. So the whole Shawcross Doctrine is very subjective.
We have 13 or let's say 15 minutes left. Would everybody be agreeable? There's 5 questions in the second round to do 3 minutes each on those 5 questions. Agreed. So that will go then Liberal, Conservative, NDP. Mr. Sassy.
Thank you, Mr. Chair, and thank you, Dean Condon. As I understand your testimony, you are suggesting that the definition of public interest is very much contested. And I had the opportunity to go over one of your publications, and it says there that there can be competing legitimate interpretations of public interest. Now, this is a publication from 2010. Would you still agree with that statement?
Yes, I know it is an academic's prerogative to change their minds, but I think that that I do still agree that there are a number of different considerations that could be legitimate to take into consideration. And that's what makes it so difficult for someone in this role, such as an Attorney General or a DPP, to ultimately have to balance and come up with an action one way or another. So I agree that it's not a singular thing, the public interest. It has a number of different dimensions. We've seen cases where questions of national security become the dominant interpretation of the public interest, but we have also seen other older cases that are, there are English cases involving questions of prosecuting strikers, for example, in the context of labor relations strife, and those decisions about whether or not to prosecute in that context have also been seen as upholding a definition of the public interest.
Thank you. Now, your co-panelists said that our DPP regime is not up to global standards. What is your view, having looked at the details? Dean Condon?
Oh, I'm sorry. I didn't realize that you were asking me the question. I thought
Yes.
It was directed to my. I think that my colleague was certainly putting a great deal of emphasis on the issue of the Attorney General at the federal level in Canada being a member of Cabinet, whereas in the UK this is not the case. And that certainly is a puzzle, because as I think both Professor Edwards and Professor Stenning have noted, it's not really clear why, if the arrangement whereby the Attorney General is kept outside of Cabinet is the appropriate thing to do in the UK itself, why that wouldn't have been exported to other countries in the Commonwealth complex. So I think that again is an issue that could well benefit from some serious consideration. And I note that my other colleague, the Dean of University of Ottawa Law School, Adam Dodek, had a column in one of the newspapers this weekend which addressed this issue in part as well. So as I said in my opening remarks, the reason for having a DPP is to insulate the prosecutorial decision-making from, from overtly political considerations. And that is another way to address the issue of how you render the assessment of the public interest somewhat more nonpartisan.
Thank you very much. Ms. Raitt.
Thank you. Thank you, Dean Condon. I'm sorry I'm going to be asking you questions too on your matter, just based upon what your testimony, and I really do appreciate what you gave us at the beginning. If I could just try to, it's not necessarily a hypothetical, but I'm trying to lay out the facts as a process. Maybe you can help me understand based upon what you've said. So a decision to prosecute has been made, and the criminal proceedings have a date for a preliminary inquiry 6 weeks on. The Attorney General has decided they're not going to intervene, and they've said so. But the pressure continues on the Attorney General to change their mind. And where I'm going is this, it's that for me, it was interesting for you to talk about the remedy. So the Attorney General continues to get submissions. And what you said parliamentarily, either they're accountable to Parliament for the decision they made, and I accept and agree, but then you said that resign if she didn't think she had the confidence of Cabinet. But if nobody told her she didn't have the confidence of Cabinet, how would she know whether or not to resign from the pressure that was putting on her? At what point does she become obliged to put up her hand as the Attorney General, given that nobody's saying you're in danger here, your job, we don't believe you, you're not doing a great job. If she still enjoys the Cabinet confidence, how would she know whether or not to resign?
Well, I do want to emphasize that the decision to resign is an extremely serious decision and should really only be taken, I think, by an Attorney General as a last resort. I don't think it's something that anybody would suggest be done lightly. And I think it would only be done in a context in which the Attorney General really felt that her or his independent judgment about when and how to prosecute was not respected by colleagues. But as I say, I thank you for the opportunity to clarify that is a really last resort response, I think, by someone in this role.
Thank you. I appreciate that. And Mr. Chair, for the record, I wanted to clarify, I wanted to correct something that the honourable member said with respect to the resignation of Mr. Smith in British Columbia. If you read the Hansard in his actual speech, what he indicated is that he resigned from Cabinet because the Premier was removing him from Cabinet as the Attorney General. He felt he needed to resign in order to be able to tell the truth about the fact that the Premier's office was undermining and eroding the independence of the Attorney General. That's the reasons for his resignation. So I have no other questions, Dean Condon. Thank you very much for answering the one I had.
Thank you very much, and you hit exactly 3 minutes, so congratulations. So now we go to, it's Mr. McKinnon, then Mr. Rankin. Mr. McKinnon, then the Conservatives, then Mr. Rankin. Mr. McKinnon.
Thank you, Chair. My question is for Professor Condon. You said that advice is one thing, pressure is another. The testimony of the Clerk of the Privy Council last week said that pressure is the name of the game for ministers. Everything they do is subject to pressure. And the AG is really no exception. So I think I would ask you, I think what we're talking about is undue pressure or an inappropriate level of pressure. Would you agree?
I'm not sure I can speak to this general concept of all cabinet ministers being placed under pressure, but I guess the reason we're all interested in this question about the Attorney General is because the Attorney General has an extremely specific and critical role within, within the governing principles of our democracy, which is that the Attorney General is responsible, he or she is not the only person responsible for maintaining the rule of law, but she or he clearly has a dominant concern for the maintenance of the integrity of the administration of justice and public confidence in the administration of justice and the pursuit of the rule of law. And so I think that's the reason why, why there's particular attention paid to the independence that is required for that particular role in order to discharge the responsibility appropriately.
Excuse me, but I certainly don't question that there needs to be independence, but I believe that in cabinet and pretty much every decision they make, there's a lot of pressure. People are trying to influence cabinet ministers all the time. That's one of the things they do. So I guess I'm submitting to you that what we have to consider here is whether there was an inappropriate level of pressure applied. And if you can agree with that, I will ask you, what would constitute undue pressure in your view, and who would decide? And since I've probably run out of time by then, what recourse would the Attorney General have in the event that the given Attorney General felt that he or she was being subjected to undue pressure?
I think I'll address the last aspect of your question first, which is that, I think this comes back to the question of parliamentary accountability in the sense that, one remedy for the Attorney General who finds him or herself in that position is to seek to describe that circumstance in Parliament. However, in a context in which this is all happening with respect to a decision to prosecute or not to prosecute, the challenge is that I think most people in the position of Attorney General or DPP would need to wait until a matter had been concluded so that they were not influencing the procedure of the matter that's being that's going through the criminal justice process before they would speak on those issues.
Thank you. Mr. Cooper? It's Mr. Cooper, then Mr. Rankin.
Oh, okay. Sorry, I thought I was going to go next. If Mr. Rankin wants to go ahead,
I have no problem switching that around. Mr. Rankin?
Thanks a lot. I guess I want to Professor St. Hilaire, please. You said two things in the last intervention I found very important. The first is you said what counts is did she make her own final decision? And of course she did here. There was a decision on September the 4th, and then it was clear that the Attorney General was not going to change it. And then you said about the deferred prosecution agreements that it was, I think I'm quoting you, clear as black and white that you could not apply under that statute the national economic interest. It was just not, it was clear that that was not a factor that could be applied in that circumstance. And so my question is, if the final decision was made by the DPP and the former Attorney General, what possibly could be proper in terms of conversation with the then Attorney General after that time? Do you agree with Mr. Andrew Roman, who wrote that the only reason for either of them, the Prime Minister or his senior staff, to discuss her decision would be to encourage her to change it without being seen to do so? This is damaging to the rule of law, close quote. Do you agree with that?
I find it very difficult to see how, once the decision is made, how the theory can be properly applied, how information can be useful if the decision has already been made. If there are cabinet discussions after that decision has been made, then I find that quite difficult to understand.
Picking up on that, Professor St. Hilaire, you said that you would find it difficult to construe how any further information could be useful once the Attorney General had made her decision on the matter. I guess it would also be further problematic if the nature of those discussions related to matters that were expressly precluded. Would it not? I mean, that could amount to some indication of some level of pressure, really.
Well, yes.
Kinnan made the comment that people try to influence cabinet colleagues all the time, but clearly not in terms of the Attorney General exercising his or her prosecutorial discretion. Wouldn't you agree?
C'est pas censé.
That should not be done. It should not be anything other than useful information provided. It should not be pressure. I would also like to come back to the remedies because I think that there is a clarification that needs to be made here. I'm not sure if this is the right time, but I wanted to add regarding remedies and the application of the Shawcross Doctrine. We talked about the accountability to Parliament, but I want to emphasize something. We need to make a distinction between accountability by the government to the House and individual responsibility of ministers. Ministers are individually responsible for the actions of their departments, and everything concerning discussions in cabinet, when there is any kind of dissension or arguments, conflict, that is covered, and that is cabinet solidarity. So the Parliament has very little room to maneuver in trying to find out whether the Shawcross Doctrine has been properly applied or not. So it doesn't really cover cabinet discussions. If there has been a lack of agreement within cabinet, it's hard to get that information to come to light. So it's hard to apply, in my opinion.
Colleagues, Mr. Fortin is asking if he can have 3 minutes. What are your thoughts? Is it okay? Monsieur Fortin, vous avez 3 minutes.
Merci, Monsieur le Président.
Mr. Fortin, you have 3 minutes. Dean Condon, you said earlier that the Attorney General has to make sure to have the confidence of Cabinet at all times and otherwise should resign. So my question is, do I understand by that if he or she no longer has the confidence of Cabinet and does not resign, then the Prime Minister could legitimately force her to resign? And if not, what does she risk by not resigning in those circumstances?
What I would say about that is that the critically important role that the Attorney General has to administer justice and pay attention to the rule of law is the consideration that needs to be uppermost in the Attorney General's mind. Again, without specific facts before us, it's hard to imagine a circumstance in which if the Attorney General's independent decision-making was being somehow undermined and the confidence in her or his independent decision-making was being undermined by his or her colleagues, that it would be possible to continue to execute this really difficult role that this individual has to play. Having said that, as I said earlier, the decision should not be simply, it should not be rendered in a context in which there might be an individual disagreement about a particular interpretation of the public interest. I think this does have to be a rather serious demonstration of lack of confidence before the Attorney General would take that very dramatic step. And I think I'm not quite addressing the first part of your comment. Perhaps you could repeat it for me, because I think I've wandered somewhat away from it.
J'ai pas entendu la fin, ça coupé.
Elle vous a demandé.
No, she asked you just to ask the first part of your question again. The first part was that I understood from your comments earlier that the Auditor General needs to resign if confidence by the cabinet colleagues is lost, so that there needs to be that cabinet confidence in those actions at all times. So if that confidence is lost, what is the risk if he or she does not resign? For example, a demotion, or what would be the risks?
As I say, I think the reason for resignation is the inability to continue to discharge the role of Attorney General specifically. And again, to reiterate, this is not something that should happen easily, but needs to probably occur if there is some significant a series of events that occur that make it difficult for the Attorney General to continue to discharge the role. As to the question of the appropriate characteristics and qualities that are needed to fulfill the role, presumably there are opportunities for cabinet to determine that in specific factual circumstances, it may be preferable for someone else to fulfill the role. But again, the risk is for the group of cabinet ministers as a whole that that they are also subject to public and political accountability for those kinds of determinations.
Thank you. Thank you very much. So, colleagues, we've exhausted our time on the first panel. Before moving to the second panel, we have a budget in front of us that I just for the study or for these meetings that I would ask if everybody would be prepared to accept. It's for $5,900. Colleagues, everybody agreed? Thank you. So we'll just take a brief pause of the meeting. We'll just recess briefly to allow the second panel to be set up. Thank you. Second panel of the day. It is a great pleasure to be joined by Ms. Mary Ellen Turpel-Lafont, Senior Associate Counsel, Woodward and Company, and Professor at the University of British Columbia in the Law School. Welcome, Ms. Turpel-Lafont. Thank you for joining us. And then here in the room, we have with us Ms. Wendy Berman, who is a lawyer and partner at Castles Brock and Blackwell LLP. Welcome. And Mr. Kenneth Jewell, lawyer and academic at Gardner Roberts. Welcome. And so, as per our practice, we normally go with the person on video conference first in case anything happens to the connection. So, Ms. Turpel-Lafont, the floor is yours. You have 8 to 10 minutes.
Thank you, Mr. Chair. First of all, I can say that I did have a chance to listen in to the earlier presentation and to hear both of those presenters and most of the questions. So I regret that I'm not there in person today. But I was able to hear from it, and of course they've covered a fair bit of ground in terms of the rule of law and the applicable legal principles that govern these issues. I do have some points of difference that I would like to address and be happy to answer questions on. In particular, I think that what we assess as being rational or not rational requires a much more profound understanding of the facts here. And in terms of the law, I think we understand that the rule of law requires that all public officials, when they act, must have a lawful authority to point to, consistent with the rule of law, consistent with our constitutional conventions and principles, and consistent with the important independent role that the Attorney General plays. A slight point of distinction, I think, in my view, with respect to the matter is there is a fair amount of discussion about the obligation of the Attorney General when acting as an Attorney General that they should resign. And I did have a chance to listen, and I would have some distinct views on that from what I've heard in your prior panel. I think again, we do not know the full facts, and facts are very significant. There's nuances that are very critical here. But I do think that there could be a rational explanation as to why an Attorney General acting as a Chief Prosecutor and Chief Law Officer of Canada would not resign when their prosecutorial independence was challenged. And that's because I think it is a constitutional requirement consistent with the rule of law in Canada that prosecutors do not resign, that they stand firm in the face of pressure if there is pressure, and I appreciate that's not factually fully established, and they stand firmly in the defense of the rule of law. Prosecutors are very rarely fired for doing their job, but if an Attorney General was proven to have stood firm in her decision-making as a prosecutor and as a lead prosecutor for Canada, namely as the Attorney General enmeshed and embedded in this very significant and well-articulated rule of law function, I think there's a very concerning situation if she would have been removed. So the issue of resignation versus removal, it may very well be that we have a situation where we have a prosecutor that was removed from her role as opposed to an Attorney General that should resign, because in fact prosecutors should not resign. Lead prosecutors, when they've taken a decision, should hold firm in their decision, and that is consistent with the rule of law. Alternatively, I think it's important that those who may seek to influence or seek to engage the Attorney General when she's wearing that hat as Attorney General, and I agree with the former panelists that the Shawcross Doctrine is a fairly flimsy basis to blanket oneself in terms of a public official saying, I can approach the Attorney General and vigorously attempt to persuade her to another view because I have this Shawcross Doctrine. I think Shawcross has to be understood more broadly within the Constitution of Canada, the principles of the rule of law, which have been very clearly upheld in Manitoba Language Reference, the Secession Reference, the Judges Reference, and others. I think the issue of the Attorney General acting as prosecutor is that they should remain firm. So someone who is seeking to invoke the Shawcross Doctrine to say, I have lawful authority to approach an Attorney General and seek to convince her of another view, I think that's a fairly flimsy foundation in terms of lawful authority. I would be very careful about pointing to that. And I would just say that all public officials, members of the executive branch, administrative branch of government, must always point to lawful authority for the actions that they take. And it must be clearly articulated, and it must be evident. And I think if there are ambiguities of any kind, those ambiguities will always be resolved in favor of these very significant independent and quasi-judicial roles like the independence of the Attorney General of Canada. Obviously, the independence and the role of the Attorney General is not always subject to scrutiny and review, such as we are talking about it today. In the context of actual prosecutions, obviously there's been a fair amount of scrutiny of the role of the prosecution service and the prosecutors of Canada, whether that be because of the Charter of Rights issues, whether because of issues where there's impropriety and there may be torts of malicious prosecution. These matters do come to the courts in different ways. But the actual exercise of the discretion to decide to pursue a prosecution is something that is really not looked at unless there is, I think, as the late Justice Mark Rosenberg said, flagrant impropriety. So I think that some of these principles are fairly well established. The prosecutorial function has to be exercised independently. We've identified that and we understand that. And the decision points in the prosecution role, including the decision to pursue a prosecution, once that commences and we then go into a court process, whether that's a preliminary inquiry stage, whether that's a trial, and again, having been a judge and run many trials, there have been many times where we start a trial and it ends up with a resolution, where I certainly would have counsel appear before me and say, you know, Your Honor, we have a joint submission on a resolution of the matter we'd like to put to you. We were well out of the starting gates of the trial, but things change. So in prosecutions, things do change, but they change within a scope of decision making that has some very definite parameters. They change because there may be difference in terms of a likelihood of conviction of one offense. They change to spare perhaps a victim having to testify. They change for a whole variety of reasons. But of course, we do promote resolution of matters without having every case fully tried. But when a prosecutor has decided to test before a court the evidence that the investigative branch of government has prepared for them and pursue a prosecution, that decision is a very significant decision point. There is limited lawful authority for anyone to intervene at that decision point and going forward. And if in the instance that you're examining, as I say, we don't know the facts, but if in the instance you're examining, we're finding there is interventions that are seeking to address that decision point, I think that's a significant, very significant issue that would attract concern for the rule of law in Canada. Of course, having worked closely with prosecutions and understanding how prosecution service works, I can say that prosecutors are very well trained. They hold themselves and others to account, and if there's any indication that decisions stray from lawful considerations, they are able to establish boundaries. And I'm not sure in this instance if this is a case where there were not the ability to establish boundaries, but perhaps this is an instance where a prosecutor was actually fired for establishing a boundary that was not popular or accepted. I'm not sure of that. I think that there is some suspicion and concern here about that. I would also say that to the extent that we have any ambiguity about what the rules that apply are, I think the ambiguity rests in the issue of what lawful authority public officials or other members of the executive branch of government rely on to justify their action. And I haven't followed the matter very closely, but other than the Shawcross Doctrine, which I think is a somewhat flimsy foundation for this, the lawful authority is somewhat shaky in terms of being able to intervene with a prosecutor. I do think the facts are extremely important. It is not inappropriate for a public official to engage with prosecutions and say, should you require additional information, I am standing ready to provide it to you. I think that's a fairly fair position. I think when we get beyond that position of the more passive and respectful approach, and we get into a very vigorous position of saying, I challenge you to take a different position, I think we are into very serious issues with the rule of law. And there's a variety of factors at play. Some of them were identified by the previous panelists, but certainly we would need to understand very clearly how that experience or how that situation may have unfolded. And I'm not to suggest by any means that an attorney general is a thin-skinned individual that can't take pushback. The issue is the propriety of entreaties that may be made to an attorney general. The propriety really goes to the zone of for what purpose. If the purpose was to persuade the attorney general as chief prosecutor to take a different position on a prosecution, it triggers a serious rule of law concern. And how will we know whether that's serious or not? Well, obviously you need to hear from those who may have been involved, maybe this is completely unfounded and we have no reason to be concerned about the rule of law. I certainly would hope that that's the case. However, when I think about the sort of spectrum of entreaties that can be made to an Attorney General, I think there's a range that would be very troubling to me, and there's some that would be deeply troubling to me. One of the areas that would be most troubling to me would be if public officials and members of the executive went to an Attorney General and said, I don't like the decision that you've reached, and I would like you to get another opinion from someone else. That would be very troubling. I'm not saying that is the case here, but that's an example upon reflection of where I think it's somewhat of a repudiation of the decision point role for the Attorney General as lead prosecutor. If the discussion was, as I said earlier, really to indicate point of information, there's material that we may share should you be interested in receiving that. Now, in between those two extremes, one of we may insist you get a different opinion because we don't agree or respect your opinion. I'm not saying that applied here, but if that did pertain, that's very serious. And we're standing ready to provide information if you want it. There's a whole range and degree of entreaties that could have occurred that would all engage serious rule of law issues and would need to be carefully examined incident by incident if they happened. Obviously, in terms of the rule of law,
Mr. Pellefonds, just to give you a caution, you're at 12 minutes. So if you could wrap it up in the next minute or so, that would be amazing.
I will, and I apologize. The final point I wanted to say about the exercise of lawful authority and prosecutorial discretion is the rule of law is informed by our conventions, our practices, our legislation that govern prosecutions, prosecutors' desk books, and other things inform our rule of law. But what also informs our rule of law are our international conventions and obligations. So if we have international normative standards with guidelines, for instance, with respect to how bribery or corruption offenses are prosecuted so that we're a global citizen and part of a broader legal network, those factors would also be part of the rule of law in Canada. So those considerations about being a good adherent to, say, international conventions and treaties. I think there are 3 global treaties or 3 international treaties, including the OECD treaty applying to bribery and corruption. Prosecutors would be expected as part of the rule of law to consider those factors. Those are important factors where we have multi-state treaties at an international level. They become part of the rule of law of Canada as well. So I will just end it there to say that these are nuanced issues. Obviously, I've heard the prior panel. I affirm much of what they said, although I take some different understandings of it. And I would just suggest to the committee that any entreaties to an Attorney General exercising the authority as a chief prosecutor, that those engaging in that must point to lawful authority that actually backs up their actions. And I would say the Shawcross Doctrine is a flimsy authority.
Thank you very much. We're now going to go to Ms. Berman. Ms. Berman, the floor is yours.
Thank you, Mr. Chair, and thank you, members of the Standing Committee on Justice, for inviting me to participate today. I have come to speak to you about remediation agreements and deferred prosecution agreements as defense counsel who has been involved in negotiating such agreements. As you well know, the regime in Canada on the criminal side is recent, and so there are not a lot of deferred prosecution agreements in that context, but in securities regulatory enforcement context and other contexts involving allegations, serious allegations of complex corporate misconduct, those prosecutors have a panoply of tools in their toolbox to deal with corporate misconduct. And in terms of that, one of those tools is a deferred prosecution agreement, and I have been involved for many years in a number of contexts to ensure that that tool was available to prosecutors. It has a negative connotation in some spheres as being a way for corporations to buy out from their responsibility, and that misconstrues the nature of a deferred prosecution agreement. and the unique nature of a corporate organization that is facing allegations of corporate misconduct, such as bribery, such as securities law disclosure violations. Those are the corporate entity that is charged with that offense or facing an investigation into such allegations is unique and different than individuals charged with those very same allegations of misconduct. So the deferred prosecution agreement, in terms of its nature, it does hold the corporate entity to account for the misconduct. It does meet, in my respectful view, all of the objectives that are necessary for a robust criminal justice system. And it allows, more importantly, for benefits that aren't available from the rigidity of conviction, no conviction, binary regime. In particular, provided that a deferred prosecution agreement regime is robust, which in my respectful opinion, the regime implemented by Canada is a robust regime. It's very similar to that adopted in the UK and has improvements, I think, that make it different than the regime adopted south of the border in the United States. So, for example, corporations availing themselves of a deferred prosecution agreement will take account and responsibility for their conduct. There will be a statement of facts in any deferred prosecution agreement which outlines the nature of the conduct involved. And there will be terms in a deferred prosecution agreement that include remediation terms, both in terms of enhancements to internal compliance regimes, a financial penalty, so reparation for the conduct accused, and in terms of the criminal justice objectives, it meets those in terms of assuming responsibility. It meets those in terms of ensuring the harm is addressed to the marketplace and to those affected by the conduct. It meets that in terms of ensuring deterrence. The most important part of a deferred prosecution regime is that our remediation agreement is it allows for very timely resolution. These are complex issues and complex conduct that's involved. So typically, these prosecutions take multiple years before there's any statement to the public or any guidance to the public in terms of what is expected. So the real benefit for a deferred prosecution agreement for the country as a whole and for our markets is that it allows for us to move that needle. It allows for a prosecutor to make a statement regarding what is expected in terms of evolving best practices for corporate governance, for compliance regimes, in a very timely manner without the delay that we would see in a normal prosecution. And the other very important part, it avoids the collateral damage. A corporation acts through individuals. And if a corporation is to take steps to address alleged misconduct and to improve its regime and to address the wrongdoing done by individuals through disciplinary action, through a change in the upper level or the medium level of management, to remove those who were responsible for the misconduct, and to, in that situation, improve its own internal compliance regime through a remediation agreement, then it meets the objective by moving the needle, as I said before, in terms of enhancing best practices for corporate governance for corporations and setting a standard in which all Canadian corporations will have to meet and improving that standard. The collateral damage from the binary conviction, no conviction regime is that today's stakeholders pay the price of a conviction. And so in certain circumstances, it may be appropriate to explore a deferred prosecution agreement in order to avoid that collateral damage. And the collateral damage will be felt by all who are involved with the corporation, whether they are employees, pensioners, business partners, suppliers, downstream, upstream business partners to that organization will feel the impact if that organization faces a conviction and the resultant reputational harm, as well as the harm to its business from a conviction that may make it impossible for a corporation to continue to operate. So there's a real risk in certain circumstances that a corporation could, for lack of a better expression, wither away and cease to exist with all of the collateral damage to those who rely on the corporation for economic benefits. And in those situations, you take the prosecutor may, in balancing what the other panel members discussed, being the public interest, may look at those factors in determining that here are some circumstances that make sense for us to look at something other than that convict, no convict regime. It's important to know that a deferred prosecution agreement is not a non-prosecution agreement, which is another tool available to prosecutors in other jurisdictions. That is a situation where a corporation is not charged, does not take any account for its conduct. Here in a deferred prosecution agreement, a corporation does. A corporation is charged. The state, through the DPP, enters into a remediation agreement which allows for a suspension of the prosecution against the corporation. And that suspension is a contingent suspension. The corporation must meet all of the terms of the remediation agreement, which, as I outlined earlier, would include a number of terms of certain steps the corporation has to take regarding its own internal organization and internal regime for compliance, the payment of a financial penalty, often the imposition of a monitor, an independent third party, to review the steps that the corporation takes, and often an obligation to report to the court or to the prosecutor on its progress in meeting the terms of the remediation agreement. And if the remediation agreement is breached, then in those circumstances, the corporation will be prosecuted. If all of the terms of the agreement are met by the corporation, then the charges are dismissed. And so the important objective in the criminal justice system for holding others accountable for their wrongdoing is met in these circumstances, and met in a way that avoids the sometimes very draconian result that can occur when a corporation is facing a conviction. And in terms of the use of deferred prosecution agreements, when Canada considered implementing such a regime, it could look to other states that had similar or had implemented deferred prosecution regimes, and it did. And Canada is now, with the benefit of a deferred prosecution regime, has this effective tool similar to many other states globally, including the UK, including the United States of America, other members of the EU, and Australia most recently has adopted a deferred prosecution regime. And when we have the benefit of looking at the experience. The U.S. has had a deferred prosecution regime in place since the early 90s, so for the longest period of time in that list of people. Their regime is different than Canada's, but what we do see demonstrated from their regime is that it is not widely used. It's used in limited circumstances, and that's where it's meant to be used. There have to be certain conditions met that a corporation would qualify to be considered for a deferred prosecution agreement. And so we'll see, for example, in 2018 alone, across the United States, there were 24 deferred prosecution agreements and non-prosecution agreements. That is not an astounding amount as given the number of active investigations and the number of cases on the go. We see in the UK that they adopted a deferred prosecution regime in 2013, and there have been only 4 deferred prosecution agreements. So the fear around the use of them is not realized when we look around at other jurisdictions. So in Canada's regime, we have some very important attributes which make it robust, and that includes conditions that the prosecutor must meet in order to even consider negotiating a remediation agreement. One of those, interestingly and importantly, is that the DPP requires the consent of the Attorney General prior to beginning the negotiations. And then there are, so the prosecutor performs a gatekeeper role, the courts perform a very important other gatekeeper role. And then finally, and most importantly, the regime ensures transparency. So we move the deterrence ball forward, we move the needle forward on best practice for corporations, because all DPAs will be made publicly available unless there are reasons for the court to defer the publication. So I'll move it across to my colleague, Mr. Jal, who will also speak to deferred prosecution agreements.
Thank you very much, Mr. Joel.
Thank you, Mr. Chair and members of the Standing Committee. It's an honor to be invited to attend to speak about remediation agreements. Since 2014, I, along with others, have argued that we ought to have remediation, deferred prosecution agreements, and I was happy to see in 2018 the legislation passed. The legislation sets out 6 purposes or objectives in the statute, and I want to go through those. Number 1, the purpose of these agreements is to denounce wrongdoing. B, to hold organizations accountable. C, to promote a compliance culture. D, and this is a very important one, to encourage voluntary disclosure of wrongdoing. This is the idea of a company coming in from the cold and telling prosecutors something that the government hasn't discovered yet. And I'm going to come back to that if I have time. The 5th objective is to provide remedies for harms done to victims. And the 6th purpose is to reduce the negative consequences for employees, customers, pensioners, and others who did not engage in the wrongdoing. I want to spend some time on that last objective. A similar test is used in the United K legislation, which refers, as Ms. Berman has stated, to collateral effects on the public, employees, and shareholders. Now, I think we need to talk a little bit about this to understand it. Negative or collateral effects on persons who were not guilty of any wrongdoing are particularly acute if the particular corporation is doing a lot of government work. And the reason for that is because a conviction in Canada leads to debarment. And with the present regime, it leads to debarment for a 10-year period, subject to reduction to a 5-year period. So that is a very real collateral effect on employees, pensioners, and customers if the company can't tender or do government work for 10 years. Now, in order to understand this concept, and I may find myself, and I don't want to, but giving a little bit of a lecture on corporate criminal liability, but you really have to understand corporate criminal liability as set out in the Criminal Code under Section 22.2 to understand the dynamic of a corporation vis-a-vis the individuals. So let me give you an example. There's only one litigated case in Canada. It's called Petroglobal. Justice Toth in that decision said it's no longer necessary for prosecutors to prove fault in the boardrooms or at the highest levels of a corporation. The fault even of middle managers may suffice. It means that it is possible that senior managers or even middle managers acting within the scope of their authority, and that's an important point, may have committed an offense such as bribery, while at the same time many of the employees had no idea about that act. Customers, pensioners are a further step removed from the circle of knowledge about that bribery. These are the people, in my submission, that are referred to in the purpose section to reduce the negative consequences of the wrongdoing for persons who were not part of it. The reduction of negative consequences has economic consequences. An important question then is, how does this objective relate to the prohibition against considering the national economic interest? So I want to turn to that. Section 715.323 says, and I'm going to quote it because it's important. Despite paragraph 2I, if the organization is alleged to have committed an offense under section 3 or 4 of the Corruption of Foreign Public Officials Act, the prosecutor must not consider the national economic interest, the potential effect on relations with a state other than Canada, or the identity of the organization or individual involved. And this section is very similar to the UK legislation, and as was mentioned earlier, is consistent with the OECD treaty. So when this legislation was passed, I wrote about it in my text, and at the time, none of the recent events had occurred. And so I went back and I looked at what I said at the time. And I want to read to you what I said and then give a comment. So what I said at the time about this provision is as follows. This clause is designed to avoid political or economic factors interfering with the administration of justice. Conceivably, this clause prevents an organization that is a prominent Canadian company from seeking special treatment on the basis that a conviction of the corporation would impact the national economic interest. There is, however, room for such a corporation to argue that it should be considered for a remediation agreement under the purpose section F to reduce the negative consequences of the wrongdoing for persons, employees, customers, pensioners, and others who did not engage in the wrongdoing while holding responsible those individuals who did engage in the wrongdoing. Now, members of the committee, you might ask, how is it logically possible to consider the reduction of negative economic consequences for employees and pensioners and those not guilty of wrongdoing, while at the same time not considering the impact on national economic interest? It seems like it's a logical paradox, right? I'm going to suggest that there is a way out of that logical paradox, and it comes back to the concept of the essence of corporate criminal liability. So if you have a situation where a crime's committed by senior or even middle-level officials, but there's a whole range of folks who had nothing to do with it, those two provisions work together. You can give a deferred prosecution to save those people from being affected, while at the same time, it has absolutely nothing to do with the economic interest. It's designed specifically to deal with protecting the people who had nothing to do with the bribery. Now let's take the complete reverse scenario. Suppose you have a company where the corruption extends right down to most of the employees. Suppose you have a company that really can't say there are a lot of innocent folks. If that company goes to the prosecutor and says, we still need a deferred prosecution agreement, not because we're protecting innocent people, but because it's in the national economic interest, you can't let us fail, that's prohibitive, in my view. And then there's all sorts of permutations and combinations that apply to considering the situation for pensioners and or customers in that scenario. So each case, as has been said before by the prior speakers, needs to be evaluated on its facts. There are no simple answers here. Now, I want to briefly touch on something that Ms. Berman talked about. She's spoken a lot about deferred prosecutions as not being what I call free passes, and I'm not going to spend much time on that because she's done such a great job doing that. I think the one thing I just would want to say is that when we talk about these arcane examples, you need a fact pattern to give it substance. So let me give you an example of one that happened recently. Panasonic in 2018 received a deferred prosecution agreement in the United States. They had been accused of paying bribes to get their entertainment systems through a subsidiary onto Middle Eastern Airlines. And they paid, over a period of time, about $7 million and disguised this as consulting fees when they weren't really consulting fees. So they not only were paying bribes, but they were falsifying books and records. They received a deferred prosecution agreement. But to Ms. Berman's point, listen to the penalties. the disgorgement of the profit, they made profit of $126 million. That was disgorged. They had to pay that back. On top of that, they then had to pay a penalty of $135 million, and that was with a 20% discount. And then they had a monitor imposed for a period of 2 years. So that's a good example of how powerful these can be. There's been a lot of people talking about gatekeepers. I'm not going to comment on that because people have done such a fantastic job, except to reiterate one point, and that is what people haven't been talking about a lot is the fact that because the Canadian system requires court approval, a judge ultimately has that ultimate approval. So, and I'm speaking completely hypothetically here, but even if an attorney general felt pressured and ultimately put something before a court as a remediation agreement, a judge has the right to say, I need to know what are the factors. The judge in our legislation has to be satisfied that it's fair, that it's appropriate. And a judge could say, if you are considering only the national economic interest, that's a prohibitive factor, and I'm not going to approve this agreement. So there is that judicial check, and we have to keep that in mind. One of the things that I'm sorry to run out of time, so I'll probably save this for questioning. If anybody's interested to know, I'm happy to talk about the whole concept of coming in from the cold and how it applies, because it's something I think is important in this specter. And I think the last thing that I'll say is this: this is complex. This is like and we're neophytes as Canadians. I think we ought to give some serious thought to the passing of guidelines. This legislation gives the cabinet power to pass guidelines for the implementation of remediation agreements. I think we ought to set up a panel of some really smart people, some of whom have come before you, and let's sit down and, not saying I'd be one of them, but get some really smart people together and study this so that guidelines could be passed by way of regulation that would help both the Attorney General, the Cabinet, and the parties understand the differences between some of the factors that may be more partisan and some of them that are more legal. Thank you.
Thank you very much. We will now go to one round of questions, and then we'll see where we are after that. So, Ms. Raitt, you're up first. 6 minutes.
Thank you very much, Mr. Chair. Professor Chappell-Lafond, thank you very much for your interventions, and thank you for all the work that you do as a voice for children and youth in this country. You've done an incredible amount, and I really do appreciate it. I do have a question for you, and it has to do with something that you said on TV recently. And if I could quote, it was, "A political official or an administrative official in government that attempts to influence a prosecution is not only immoral, but it is illegal." What did you mean by illegal?
Well, I think, first of all, it's very important to look at the context. I think that was a quote perhaps from the Globe and Mail when they put a scenario to me. But what I mean is pretty much consistent with what I've said today, which is all public officials must point to lawful authority to ground their actions. If it's senior administrative officials in government, whether it's in the Privy Council office, the Prime Minister's office, whether it's the Prime Minister or a member of Cabinet, all public officials must point to lawful authority. So if any public official seeks to influence a prosecution in any form or bring information to a prosecution, they must point to lawful authority for that. And in my respectful view, the Shawcross Doctrine is very flimsy authority in terms of the rule of law in Canada. And whether or not it even has the status of a legal convention, what does have a clear legal status is the independent and quasi-judicial role of the Attorney General and the Director of Public Prosecutions, who's an associate assistant Attorney General. And certainly I'm very reluctant to ever be in a role to play prosecutor because I highly respect the decisions of prosecutors. I do not think prosecutors are unaware of their lawful obligations, but I do worry about people who approach prosecutors and claim to be able to have discussions with them and claim that there's legal authority. They must point out explicitly the legal authority, because these are highly sensitive issues, including we have a range of offenses in the criminal code that speak to integrity. So one should be able to point very clearly to your committee to what legal authority they are claiming should they be seeking to intervene with an attorney general who's made a decision on a prosecution.
Thank you. You also mentioned today that we need to understand clearly how the fact situation has unfolded, and I take the point very well because I don't think we know the conversations that have happened and what the content of it was. But you did say something else, and I'm sorry to quote you back, but you said if there's evidence, if the story proves accurate, then this must be turned over to the RCMP for a full investigation. I'm trying to get my head around what breach would it be. So the public authority does not have, as you pointed out, they're not grounded in terms of what legal authority they may have to intervene with the prosecutor. What is the response in terms of what they have possibly breached within the criminal code?
Well, there are issues of integrity and ethics. It's a spectrum. The criminal code issue, and I'm not suggesting there's been a criminal offense, I'm saying that integrity unit in the RCMP should thoroughly examine the issue, and they may very well be examining the issue. I think they indicated they were aware of the matter. And these are the issues about positive obligations. If, for example, the Attorney General acting as the lead prosecutor for Canada in this very important role was actually fired from her job because she didn't make a decision that comported with her colleagues or whomever, and I'm not saying this is the case, but if she did get fired, I do not think the obligation is on her to resign when she, arguably a rational person may say you don't have to resign because you're being a prosecutor. But if there's evidence that a prosecutor was fired and there was an attempt to influence or direct her attention to something that didn't have lawful authority, then it does raise the specter of obstruction of justice, because obstruction of justice requires this sort of fear or favor element. And I think we have to come back to this key piece, which is when someone is making entreaties to the Attorney General, is the subtext of those entreaties and implied in those entreaties that you will lose your job if you do not listen to me? This is why the rule of law issues become not only engaged, but it could potentially be very serious. I hope it isn't, because it affects public confidence. But because it's so serious, we have to look at it from every angle of integrity, including our normative systems, which appear in our criminal code, our rule of law principles, which I appreciate you're studying today. But one of the critical rule of law principles, I'm flipping it back, is saying, if you seek to influence a prosecution, you had better be able to show lawful authority for your action. And if your only basis of your lawful authority is to say a 1951 political convention that really doesn't even comport with our constitutional order in Canada, then I think we should be looking at that very carefully.
Is that it?
Thank you very much. Yeah, we're at 6 minutes. Thank you so much. We're now going to Mr. Assassi.
Thank you, Mr. Chair. Now, if I can turn everyone's attention to deferred prosecution agreements. Ms. Berman, I understand that you've been practicing in this area for many years. We heard from Mr. Joel that he's been an advocate of these agreements since 4 years ago. My understanding is that there has been a lot of chatter and discussions amongst leading Canadian experts on the need to have a DPP regime for many years now. How long do you recall this discussion having been going on for?
I'd say the discussion about deferred prosecution agreements has been going on probably as long as I've been practicing, and I'm going to decline to say how long that is. But it's been a discussion for quite some time, and whether it's quasi-criminal or regulatory responsibility for corporations, it's been a discussion in all three spheres, and certainly it's come in faster in other spheres, which we've seen great result in terms of the objectives that I talked about before, but not and limited use of it in the appropriate circumstances.
Thank you. So good to know that it wasn't a surreptitious development that was introduced last year. Now, one of the members of the opposition on this committee said a while back that the government snuck it into the Budget Implementation Act. There were no consultations held by Justice Canada. Could you tell me if there was a consultation process in place in the fall of 2017?
Yes, there was. And in fact, a number of people participated in that consultation and either put in written submissions or appeared at roundtable and other discussions. I put in submissions in terms of the deferred prosecution agreement jointly with another law firm. I know that, I don't have the numbers offhand, but I believe they received close to 40 written submissions, and then there were a number of people that came and made oral submissions. There was, in my view, a very broad consultation process around the implementation of deferred prosecution agreements, but 2017 wasn't the first time that that was discussed and had been discussed with government officials about bringing in a deferred prosecution regime. It was the first time that I can recall a very formal process to consult stakeholders, both defense counsel, prosecution, corporations, broad consultation.
Okay, so according to the government itself, there were 70 submissions that came in, and there were 370 Canadians, industry associations, businesses, and NGOs that took part in the exercise. Mr. Joel, do you think that is sufficient consultation, or did you actually partake in that process?
So the two parts of that question. I certainly, as I say, advocated in my writing and my teaching, and I was part of a round table. But then I happily came here to Ottawa in the fall of 2016 to do an interchange with the Competition Bureau, and at that time became a Department of Justice lawyer for 2 years. So I couldn't participate actively in that capacity. But with respect to the number of consultations, I mean, it's a hard, subjective question. I think that this was important legislation. We can always have more study, of course, but you know, there's an expression that some people have, which is analysis paralysis. So, you know, at some point, it's appropriate to move forward, and I think that this legislation was carefully drafted in that regard.
Thank you for that. Now, it appears pretty straightforward to me that given developments that we heard about in other jurisdictions in the world, that the government's attempt to adopt this legislation was really meant to level the playing field. I know, Ms. Berman, that in your writing on this, you have referred to this development last year or 5-6 months ago as Canada as playing catch up. Could you elaborate on that for us, please?
So, as I said, we saw the U.S. being at the forefront for deferred prosecution agreements and non-prosecution agreements and no contest settlements, sort of a whole panoply of tools that prosecutors can use to resolve corporate misconduct. And so Canada never had it for pure criminal allegations and investigations against corporations. And so that's the catch-up. The UK brought it in 2013, a regime which ours is largely modeled after. And so what we were missing was the ability, we were not harmonized with other major economic players and globally. And it made it very difficult because the reality is most corporations are global entities. They operate around the world. And so we weren't able, in many cases, to negotiate a global resolution because of the lack of that tool in the kit that other nation states had. So we certainly were playing catch up, and we made it.
Thank you.
Yeah, Mr. Sessi, you have like 15 seconds left if you want to rattle something quick off.
Well, the Made in Canada version that it was adopted, do you think it's more robust than the British system, given the use of judicial approval and oversight and the use of independent monitors?
Quick answer, please.
I think it's very similar to the UK system because both have the judicial supervision model. By the way, in the United States, there's some discussion by some judges that they want to do that, but ours is pretty close to the UK model.
Thank you very much. Mr. Rankin.
Thank you. I'd like to start by welcoming particularly Professor Turpel-Lafond, who I think lives in my home riding of Victoria, so she's particularly welcome here, Mr. Chair. I want to take you back to some of the things you said in your opening remarks. You talked about the importance of defending the rule of law, and that prosecutors ought not to, in fact, succumb to pressure and resign. And you said we're into serious issues here with respect to rule of law, particularly as we focus in on what you called the propriety of entreaties to the Attorney General. You also said in the context of this that we need to hear from those involved. So I presume that that would mean that you would accept that in these circumstances, to clear the air and to do our job, we should hear from those involved, not just the former Attorney General.
Yeah, well, yes, of course. I mean, I think that in the interest of transparency, this has become a very almost of the character of a crisis in terms of the rule of law.
Thank you.
Which requires whether this committee or more generally an inquiry of some kind needs to hear fully from the critical individuals. But of course, the Attorney General is a very significant individual that will need to share her experience. Whether she can share that experience in your committee, I don't know. I mean, she will,
for her to
even
tell
if she
us.
has lister clients.
Yes,
even
I
if
understand.
her privilege is waived.
I simply wanted, in the interest of time, you know, we're very limited, to confirm that you said we need to hear from those involved, which I'm pleased you agree includes more than just her.
Absolutely. You need to hear fully from all involved.
Now, you see, I agree with as well the Liberal Member of Parliament for Toronto Beaches, Mr. Erskine Smith, when he says, when it comes to the merits of a remediation agreement with this particular company, SNC-Lavalin, I quote, whether or not an intervention by the Prime Minister's office may have been justified in substance, the real question is the nature of that intervention. Specifically, was undue pressure exerted contrary to the Constitutional Convention of Attorney General Independence, close quote, which seems to me very similar to the points that you were making here with us today. I'd like to turn, if I could, to Ms. Berman, who talked about the deferred prosecution agreements, and I appreciate your experience in the field and with corporate misconduct. You know, the history of Canada in this area, I wanted to see if you agree, is rather limited. Canada has been criticized by the OECD in 2011 for its lack of investigators and weak penalties in the rare event of a conviction. Last year, Transparency International, in its annual report entitled Exporting Corruption, talked about the fact that not only is Canada characterized by, I quote, limited enforcement, it found that it was one of 4 countries that had, quote, regressed in terms of the application of the Corruption of Foreign Public Officials Act. So it's rather grim, and one hopes, therefore, that we continue with prosecutions, and that might have been what led an independent director of public prosecutions to not waver, to not decide to enter into a DPP, and for the Attorney General to sustain that. After that, of course, the evidence would appear to show a considerable intervention by other cabinet ministers, PMO officials, and the like, to get her to change her mind. So talk to us a little bit, if you would, please, about the importance of going after people under the Corruption of Foreign Public Officials Act and Canada's record in that regard.
So Canada's record is, has not dedicated the same resources, even on a per capita basis, that you see the U.S. Has dedicated to investigations of foreign corruption. But, in terms of prosecuting and enforcing the law on foreign corruption, that involves investigations and prosecutions and taking matters to trial. It's the entire range. And so entering into a deferred prosecution agreement with a company that has been charged would not indicate lax enforcement by Canada, in my view. What indicates lax enforcement is probably more the number of investigations and the length of time. And that's because foreign corruption is very complex to investigate and very resource intensive. And you have to go to multiple jurisdictions and review millions of documents to piece together a corruption case. And as a result, you know, one of those tools, like a deferred prosecution agreement, would actually likely assist Canada in upping its game regarding enforcement of foreign corruption, because it would promote corporations to come in, self-report. It even can be a condition of a deferred prosecution agreement that they self-report and that they identify and provide information about the nature of the conduct and identify the individuals who engaged in the conduct. That would allow Canada to prosecute the individuals in a much more streamlined fashion with the cooperation from a corporation that has replaced its C-suite and replaced its board of directors with new individuals who are taking the corporation in a direction of enhanced compliance.
Thank you.
Mr. Rankin, you have about 10 seconds left if you want to fire a quick one off.
I just want to ask if either of you had any experience with doing business with the federal government that's had a 10-year rule if you've been convicted of an offense under this. And last year there's been consultations that have to maybe change the 10-year to something a little bit less. I wondered if either of you have had any experience in those consultations to relax the 10-year ban.
So again, because of my role at the government, I wasn't formally part of the consultations, but I've written about it. And, it's a very interesting new development because what it's doing is it's creating a matrix. Matrix is very critical to corporate compliance, where you look at seriousness of the conduct on the one hand, and then on the other hand, you look at the remedial effects and the attempts by the corporation to put in a compliance culture, and you balance those two. The proposals for the new debarment regime are saying, in effect, it could be up to 10 years, but lower, and it's using a more of a matrix analysis to balance those two. So if I could just take 1 minute to follow up on an earlier question, if that's permitted.
Mr. Boissonneau's time is going to start, so I think I have to turn to Mr. Boissonneau. If you manage to work it into an answer to Mr. Boissonneau, you're more than welcome.
Right.
Mr. Boissonneau?
Thank you, Mr. Chair.
Thanks, Mr. Chair, and thank you to all the witnesses for joining us today. Each of your testimonies have been very instructive, and so I come at this not from the perspective that you have, because I chose a different path and didn't go down the law school path, and come to this committee through other means, and so looking at these matters from a non-legal perspective, it strikes me that remediation agreements raise an issue for which there is public sympathy. And if I can just look at one of the things that you said, Mr. Jewell, and it's from the purposes of a remediation agreement information, it's to reduce harm that a criminal conviction of an organization could have for employees, shareholders, and other third parties. I guess in layman's terms, it's so innocent people don't pay the price for the misdeeds or the wrongdoing or the malfeasance of a few. And so if we remember the reaction of Canadians to Sears pensioners, who were last in line for their pensions, if we listen to the very real concerns of GM workers in Oshawa, workers shouldn't have to pay for the decisions or illegal activities of a few corporate executives, or even to your language, middle executives and middle management. Now, I would feel the same way if this were an oil and gas company or a mining or construction company from the West whose workers could be vulnerable if they found themselves in the same situation as the workers, suppliers, pensions of SNC-Lavalin do. So there's been some observation on the part of the Act, and it states when considering a remediation agreement, and Mr. Jewell, you also referred to this, and I quote, the organization is alleged to have committed an offense under Section 3 or 4 of the Corruption of Foreign Public Officials Act. The prosecutor must not consider the national economic interest, the potential effect on relations with a state other than Canada, or the identity of the organization or individual involved, end quote. Now, the national economic interest language is a vague term, and you also pointed us to another part of the Act that talks about mitigating the effects on workers. But even that term, the national economic interest, doesn't mean that the Attorney General couldn't consider the impacts on specific employees, for example, or pensioners, or the many thousands of people who work at the company and did nothing wrong. And furthermore, while the Act doesn't prohibit the consideration of the national economic interest, the Act expressly states that factors that can be considered can include, quote, any other factor that the prosecutor considers relevant. Again, any other factor that the prosecutor considers relevant. Would you say that leaves quite a lot of room for the prosecutor, which could be the Attorney General to consider a vague range of items, including the effects on the local economy of not proceeding down a remediation agreement. And we've already established that the Attorney General can have discussions with the Prime Minister and his or her office about such considerations. And you could imagine these conversations to be quite wide-ranging. Is it the case that the national economic interest doesn't mean that no economic interest should be considered whatsoever?
So, as I said, I really think it comes down to the facts of the case and the extent to which the corporation is corporately criminally liable. So it comes back to this notion of the senior officer. And that, to some extent, guides what section you're going to fall within. So, as I say, if you've got that situation where senior officers have committed bribery, but many employees have had nothing to do with it, I think there you can fall within the purpose section and say, we're going to protect those people who didn't have anything to do with the wrongdoing. If, on the other hand, that's not your scenario, and I'm sorry to repeat myself, but if that's not your scenario and the corporation, for want of a better word, let's just say is rotten to the core.
Very carefully, the two different
Then
kinds.
in that case, they can't go. It's a prohibitive factor. And it's pretty rare in legislation to see a prohibitive factor that says you shall not consider this. And that's what this says. So in that case, it's simply something that ought not to be on its own considered. So in other words, all things being equal, you just can't look at that factor if there's nothing else you can hang your hat on.
Ms. Berman?
But we have to also go back to the purpose, which is laid out in the statute. And the purpose does talk about the consequences, which include financial consequences to pensioners, employees, other stakeholders. So it's not as if economic harm, whether it's national, local, or to that, or regional to that, or just to that company and the stakeholders who are affected by that company. They aren't separate spheres, they're overlapping spheres, in my opinion.
Completely legitimate information to be providing to an Attorney General in the context of public interest and understanding the full context of public interest, as we heard from one of the earlier panelists, to raise these kind of matters.
So I'm not an expert, and I'm not here to testify on what can be said to the Attorney General. But I do think the Attorney General, just like the Director of Public Prosecutions, should be considering the financial consequences to all of those stakeholders as a result of a criminal conviction of that corporation. And I do think that information provided to either of those offices by anybody is important information that both of those offices should be considering in determining whether or not this is a circumstance in which a deferred prosecution agreement should be implemented. And remember, a deferred prosecution agreement can be implemented any time, even on the eve of trial and even during a trial. So there's the notion of when. I have negotiated them on the courtroom step many times. I've negotiated them during a hearing. So that consideration is an ongoing thing.
Once again, with 10 seconds left on my clock, do you both agree that remediation agreements are important parts of the toolkit for Canada?
Yes.
Yes.
Joel?
Yes. And can I sneak in my answer on that one? Okay. Look. 5 years ago, 6 years ago, before deferred prosecutions occurred, a client called me and said, Canadian company, we've discovered a serious bribery scam in a foreign country. What do we do? I said, stop it. And then they said, what do we do? And I said, we'll do an internal investigation and you should self-report. They then said, what will happen? I said, you'll be convicted. It's not the United States. And then they said, what will happen? And I said, you'll be debarred. What do you think they did?
They didn't self-report.
Of course they didn't. And that, to my mind, goes back to the earlier question that was raised by Mr. Rankin about the enforcement of white-collar crime. We don't have the resources. These are hidden schemes often. You're policing all of Canada and the world. If we don't have some sort of carrot or incentive to invite companies to come in from the cold and report things that we're not aware about, then it's very difficult.
Thank you both very much.
Thank you very much. Colleagues, we've exhausted the hour, so are we agreed that we're going to stop it here? So I want to thank each of the witnesses. Your testimony was very helpful. It's very much appreciated. And colleagues, remember, we're meeting tomorrow morning at 8:45 to deal with Mr. Cooper's private member bill. Meeting adjourned.